SJC-12486, Commonwealth v. Kayla S. Plasse.
Which one?
One more.
Mr. Gauthier, good morning.
Good morning, Your Honors. My name is Attorney Edward Gauthier. I'm here on behalf of the defendant appellant, Kayla Plasse. May it please the court. Before I descend into my argument, I just wanted to bring to the court's attention that Ms. Plasse has, in fact, completed the entirety of the sentence in this case. I just wanted to head off any argument the Commonwealth may have on the issue of mootness. I believe the fact that Ms. Plasse was able to complete the entire sentence, which was the maximum sentence allowed by law in this case, is a good sign that this type of issue is capable of repetition yet evading review.
Say she was able to. Did she serve 2 years or less than 2 years?
Well, Your Honor, she served less than 2 years. However, last month was the day that she finished her parole. So she was required to do 2 years. She had 2 months credit as of October of 2016. So as of last month, August of 18, she is no longer involved in the criminal justice system. However, I would still ask that this court reach the decision as it has taken the case sua sponte. It's been fully briefed. And the issue here is capable of repetition, and I believe it is repeated quite often in the district court. And I believe the courts would definitely benefit from this court giving guidance to trial court judges. And I would point out one thing that makes cases like this difficult. It's that judges are not required to put the rationale for their sentencing decisions on the record. We just happen to be fortunate in this case that the judge put his rationale on the record.
They don't have to, but lawyers often do, asking for enough time on the sentence to be able to get to the farm, to be able to get to a program like Howard Street where you have second offender OUIs. There are often situations, women's in transition programs that you have to be in a certain amount of time. Defense attorneys put on the record that we need this much amount of time because they are interested in what's best for their client, which is oftentimes not to be behind bars in a conventional prison, but rather at the farm or some other rehabilitative program.
That is an argument that many defense attorneys make at sentencing, and it was an argument that the attorney made on behalf of his client at sentencing. In this case, he asked for the amount of time that would have been required to complete the Howard Street program.
So should we not be able to have trial judges have a sentence that is long enough so that the person's not actually behind bars and can have a rehabilitative option because the federal courts and the United States Supreme Court has interpreted a statute in a different way?
Well, in this case, Your Honor,
A federal statute.
Right. In this case, the amount of time that the judge would have had to sentence Ms. Plasse in order to complete the rehabilitation program in a different county would have been 8 months. He sentenced her, however, to 24 months.
And that's a good point. But the question is, what if the defense attorney wanted 8 months and the judge wanted 8 months, and the reason they wanted 8 months instead of 6 months was so that they were in the Howard Street program rather than behind bars?
I understand where Your Honor is coming from, and it comes from also the Commonwealth's brief, where an individual can't complain of an illegality he essentially invited. However, if a sentence is illegal, a sentence is illegal.
But you're saying it's illegal because of United States Supreme Court case interpreting a federal statute.
Well, I think this court has superintendent's power to dictate to trial courts exactly what trial courts can and cannot consider.
Why with our superintendent's power do we want to dictate that they have to impose a sentence that's going to have more time behind bars rather than potential rehabilitative options?
Well,
I guess what I'm saying is, I don't think going to prison and going behind bars is good for rehabilitation, but I think rehabilitative programs that don't require to be behind bars is good for rehabilitation. And so why would we use our superintendent's power to say that lawyers can't advocate for that for their clients and judges can't do it?
Well, it's not a matter of rehabilitation being a consideration. The argument is not that trial judges should not be able to consider rehabilitation when making sentencing decisions. The issue here is whether a judge should be able to sentence somebody to an extensive period of incarceration after making a determination on the record that we're not doing this to deter, it's not for incapacitation, it's not for retribution. We've decided that this individual requires rehabilitation.
But isn't rehabilitation a valid goal of sentencing?
It is a valid goal of sentencing. However, the question is then, what rehabilitates? Does jail or prison rehabilitate? And the answer is simply, historically, based on the evidence, no, it does not. And if that's the sole purpose of a committed sentence, if rehabilitation is the sole purpose of a committed
Where
sentence.
do you get that evidentiary point you just made? Is that in the record anywhere?
Well,
Isn't it the exact opposite? She sought this program because she thought it was a way of sort of short-circuiting these problems, and she needed this treatment. I'm confused about that evidentiary point.
well, the evidence cited in Ms. Plasse's brief from the federal investigation and research into this is that people do not benefit. Jail and prison do not rehabilitate. There was an amicus brief filed in this case that dives into this on the state level, where the amicus tends to show that people who are incarcerated, jail or prison, actually tend to have worse results than individuals who are not incarcerated. That if we're simply trying to rehabilitate people, jail and prison simply does not get the job done.
But I'm trying to understand precisely what the standard is that you would set. So if a defense counsel says, Your Honor, I want my client, as they did here, I want 8 months because I want him to be part of the Howard Street program, are you saying a judge can't do that if the judge determines that the appropriate punishment would only be 3 months?
Well, if the appropriate punishment was 3 months,
Appropriate punishment in terms of the severity of the offense.
right,
That the judge would say, listen, if it was, the only issue was how serious the offense was, I would give, for a shoplifting case like this, I'd give her 3 months. If the defense counsel asked for something longer, is the judge barred from doing that?
I can't, in my mind's eye, think of why a competent defense attorney would ever ask for an 8, 9, 10, 11-month sentence if a judge is inclined to give a 3-month sentence, even if 9 or 10 months will be in an environment that's somewhat more conducive to rehabilitation.
Well, what about circumstances where there may be a probation period after that shorter sentence, but there's a lack of confidence that the client will be able to fulfill probation conditions, and they're better off with a completed sentence, a longer but completed condition-free sentence? Isn't that a valid reason?
Taking an 8-month sentence to the House of Corrections rather than 90 days in the House of Corrections followed by a probationary term that an individual clearly cannot complete might be smart. But there's nothing in the record to suggest that the judge was even contemplating the idea of reprobating this individual after 3 years of nearly persistent noncompliance with her release conditions. I think it's fairly...
Even though the judge is concluding, I'm just reading this back and forth. I've never seen such a bad case of someone who just can't do it even with reflections and other programs. It's frightening because so many people in Ms. Plasse's situation don't make it. So the judge believes that this program is needed to rehabilitate her and save her life, and it's what the defense counsel asked for. And you're saying, well, he's constitutionally required or something to take a 3-month sentence in jail without all this treatment? Boy, really?
Well, we have to be mindful of best practices and what an individual in her position deserves and merits. We don't take people who commit very small crimes with no criminal record and say, well, we've identified you as an individual in need of rehabilitation, so we're going to send you to jail for 2 years, especially where, in this case, there's no analysis, there's no expert analysis, no testimony as to why in the world.
But you're saying the sentence is illegal. It's not best practices. You're saying it's an illegal sentence.
Our argument is that it is illegal to sentence an individual to a 2-year term of incarceration solely for the purposes of rehabilitation for a crime like this where the individual has no record.
If the sentence had been 8 months, as requested by defense counsel, would you say it's illegal?
That's a very difficult question.
That's why I asked it.
It's very difficult, especially since this is precisely the sentence that defense counsel asked for from the judge.
It's a statutory, it's permitted by statute, the sentence the judge gave.
Permitted by statute. The maximum penalty is 2 years, correct?
Okay.
And of course, if he were to give her 4 years, her acquiescence would make it legal.
Right, but this
However-
is something the legislature had said, if you commit this crime, it may be draconian, but if you commit this crime, you can be punished to this amount.
That is the
And a
maximum.
judge could say, you may not like it, but a judge could say, you committed this crime, you get 2 years. And that's a legal sentence, correct?
If the judge did not put any reasoning on the record for why he was giving a 2-year sentence, a 2-year sentence would have to stand. However,
But the legality in this instance is because the judge said, I'm trying to help you. So that's what makes it illegal in your mind.
the judge gave a 2-year sentence, the maximum penalty, to complete to complete essentially a 150-day program.
But if, what you're saying is you agree with me, if the judge said nothing and said, here's the case, 2 years, and walks off the bench, you don't have an appeal.
We don't.
Okay. But by the judge saying, I'm going to give you this sentence in hopes that you rehabilitate, that makes it illegal.
That's the argument.
Okay.
If there's nothing further, I would rest on my brief.
Okay, thank you. Mr. Townsend, good afternoon.
Good afternoon, Your Honor. Thomas Townsend for the Commonwealth. Less than 2 months ago, this court said in the Eldred decision that the district court judges are in the front lines in the war against opioid addiction. If that is true, then certainly the presiding justice in Orange County, in Orange District Court in Franklin County, is on the vanguard of that war. Judge Ross here has significant experience in dealing with these issues. And Judge Ross heeded the call or the recommendation not only of the probation department, not only of the defendant's family, not only of the defense counsel, but of the defendant herself, who said that she needed intense treatment in a structured environment, that traditional inpatient programs were not working, and they weren't working. She had fled from one of them. She had been expelled from 2 others. She had tested positively for drug use 5 different occasions. She admitted to drug use over and over. She had gone AWOL for 13 months, and she was fortunate to have survived that time. And Judge Ross quite clearly had her best interests in mind and very well may have saved her life. Judges are required to consider 4 factors in determining a sentence, not just whether to sentence someone, but to fashion a sentence of incarceration, punishment, deterrence, the protection of the public, in rehabilitation. The defendant's only argument before this court is that the consideration of rehabilitation in determining the length of an incarceration sentence is violative of federal law. The 1984 Sentence Reform Act, as interpreted by the U.S. Supreme Court in Tapia versus the United States. Well, Congress back in the 80s determined that parole wasn't working on the federal level and got rid of it. Congress in the 1980s determined that indeterminate sentencing was not working and got rid of it. That does not reflect our view of it in the Commonwealth of Massachusetts. We have parole, we have indeterminate sentencing. So that has nothing to do with this case, yet that is the only legal argument the defendant makes.
Now, what happens here if he gives a 2-year sentence and the parole board says, we're not going to parole you, and the jail says, we're not going to send you to Howard Street?
Well, if the defendant had been sentenced as she was here and learned upon getting there that she would not be sent to Howard Street, or for whatever reason Howard Street was no longer in existence, she could move to revise or revoke the sentence within the 60 days.
Really? Okay, you're going to basically say that when the judge makes a recommendation and the recommendation is not followed, that permits the judge to revise and revoke the sentence?
She would, if the Howard Street was non-existent, and that was not known at the time of sentencing,
So it was, no, it exists, but it's in the sheriff has a discretion whether to put her in it.
well, as this court has said often enough, that whether or not someone gets the treatment through the sheriff's department is a different branch of government, and this court has no control over it.
So he says 2 years, I want her to go to Howard Street, and the sheriff says Howard Street's booked up. I can't put her in.
Well, I mean, the judge was making the best decision he could at the time. It's still a legal sentence. It's within the statutory framework.
Well, that's the issue. I mean, it's certainly within the maximum, but any consequence here? I mean, when the judge does it for a particular reason, it's up to the discretion of the sheriff, and that reason is not fulfilled? Are you saying we should permit a revise and revoke?
Well, I think we have to give the discretion to the judge who's on the ground and who has presumably a working relationship with Howard Street. He would not send people to Howard Street if Howard Street were not taking them.
Just factually, she was sent to Howard Street, right?
That's not in the record, but from what counsel says, I presume that she was.
It's not in the record.
So let's assume that they indicted her. What was the maximum at the time for this crime?
Oh,
Had been indicted, what, 5, 10 years? I forget.
I think it was 10 years. I'd have to check the statute.
What if the judge had said, I think the best thing for her is to be held in custody. I worry about her if she's on the street. I'm going to give her a 10-year sentence. Is there any limit to the principle that a judge may consider rehabilitation in determining the length of sentence, not the probation terms, not other conditions, but the length?
I submit that there is. We do know from this record she had a minimum record prior to these convictions, or this conviction. If she were to receive a 10-month sentence, I would suspect she could make a colorable argument under Article 26, that is cruel or unusual punishment.
10 years. So you
10
would say
years
it's,
for
but it's-
larceny.
it's within the maximum.
It is within the maximum, but the Constitution cannot be disregarded by the legislature or the
Cruel and
judiciary.
unusual because the judge's motivation was to help her?
Cruel and unusual in that a 10-year sentence shocks the conscience under state law and the federal law.
Its purpose was to help her.
It was, but it could still, I think, the Constitution would trump any statutory provision passed by the legislature. It would trump any judicial decision by the sentencing judge. In addition to any Eighth Amendment or Article 26 argument, the defendant could take advantage of appealing to the appellate division of the Superior Court and have the sentence reviewed by 3 Superior Court justices. That's another mechanism to challenge such a sentence. But I think, by necessity, a certain amount of discretion must be vested in the sentencing judges to determine what is an appropriate sentence, how long the sentence must be, to weigh these 4 factors in fashioning the sentence. It's something that we all rely upon, especially in this situation where everyone in the room agreed that she needed to be incarcerated for her own life's sake. And so I think at the very minimum, this could be viewed as waived. To whatever extent it theoretically amounted to error, it's invited error by counsel. But I don't think it was error because even in sentencing to a particular length of time, rehabilitation can be considered. When I looked at this case, this court had not yet taken this decision. I was looking specifically at the sentencing in the VOP context, and the court subsequently had a broadly worded amicus solicitation. If we look at the VOP context, the one case I did come across inside of my brief is Commonwealth versus Doucette, which was a manslaughter case where the defendant had driven on the wrong side of the street at an excessive rate of speed, crashed head-on to a family. One person was killed. In addition to his sentences of incarceration, he receives a probationary sentence on the manslaughter on and after. One of the conditions of probation was that he not get a license. Well, not only did the defendant get a license, he was caught driving on the wrong side of the street at excessive speed under the influence of cocaine. The sentencing judge said that this is the worst violation I have ever seen and gave the defendant 9 to 12 years in state prison. The defendant argued that that was improper. And the appeals court, in a very good decision by Justice Sullivan, said that not only was that proper, but the judge could properly consider rehabilitation or the lack thereof in this case in fashioning the sentence. So we have a different view of rehabilitation, but that case at least stands for the proposition that rehabilitation can be considered in sentencing a defendant to a term of incarceration.
Can I focus you a little bit on the difference between the Howard timeframe and the 2 years. So the judge concludes she needs to be put in a program, right?
Correct.
Is there a disconnect between the program's a certain amount of time and the 2 years? And do we focus on that? What do we make of that differential?
Well, I think it's not clear. It's not clear in the record how long the program actually took. I think it can be inferred that the judge was shooting for 10 months because he was reasoning that you could assume half time for a House of Correction sentence, especially in Hampden County, and she had already 2 months in, so you could cut 2 months off the top.
Judge, again, my colleagues who've been sentencing on a daily basis, this is more familiar, but so the judge is assuming that the person's going to get out in half the time he's sentencing?
That's correct.
And that's why he's picking 2 years, so that it gives him 10 months for, when you add in the 2 months that's already credited? Is that?
That's from my reading of the transcript, and that's what we have in the record. Now, the defendant below made an argument that it was improper for the judge to factor in parole eligibility. The defendant did not renew that argument here, so that argument is not before this court. Strictly before this court is the defendant's argument that federal law should be imported to the Commonwealth of Massachusetts.
I
Not just
understand.
federal law, it's 1984 when the federal law was over-incarcerating and parole was being eliminated. And I think the point was that they were trying to send a message about rehabilitation. And I think we're trying to say that rehabilitation is important. We don't want to give up on people or incarcerate them any longer than necessary.
I agree with that. And the defendant's argument that houses of correction don't rehabilitate, we don't have any of that in the record. In the amicus brief, nothing of that is in the record. But I think the sheriffs across the Commonwealth would disagree with that. They take the corrections part of House of Correction seriously, especially in Western Massachusetts in the counties of Franklin, Hampshire, and Hampden County. So I think that, to the extent we look outside the record, we should acknowledge that they take that part seriously.
Well, the Superior Court's best practices essentially say you may consider the issue of rehabilitation in terms of trying to help the defendant in the fashioning of conditions, but not in terms of the length of the sentence.
Are you reading, I'm sorry, is that taken from page 15 of the amicus brief?
No. It's
Okay.
taken from the sentencing
Okay.
best practices is that sentencing judges should impose a sentence that's proportionate to the gravity of the offense, and of course here we're referring to the underlying offense, the shoplifting, or the harms done to crime victims and the blameworthiness of offenders. When reasonably feasible, impose a sentence that seeks to achieve offender rehabilitation, ... provided these goals are pursued within the boundaries of proportionality in Section 1.
Right.
So they are saying, yes, if you sentence a sentence, once you sentence, you may certainly seek to rehabilitate, but don't prolong the sentence to do so.
Two responses to that. First off, that's not an argument that the defendant here is making. That's an argument that was raised by the amicus brief in a brief submitted 2 weeks ago to this court. Secondly, in the best practices itself, in the preamble, it says that these are a set of general principles a judge may consider.
Right, there's no question they're not mandatory. So the only question is whether or not we, under superintendent's power, should adopt that, either much as we have done with regard to some other restraints on sentencing. That is, you can't sentence somebody for conduct that has not been proven. You can't sentence somebody to send a message to the community. There are things we have said a judge cannot do. So we have said that, and we've dealt with the issue. Justice Gaziano has said that if the judge remains silent, we're not going to know that they sentenced to send a message. But if the judge says, I'm sentencing you to send a message, we say can't do that. So the question is, do we not have is it a matter of us not having the authority to do so, or that we have the authority to do so, but it would not be wise for us to do so?
Well, it certainly would not be wise on this case, on this record, which was not, these arguments were not submitted to Judge Ross. He should have get first crack at anything. And it was not briefed by either party. It was raised by the amicus brief. To the extent that this court has authority, presumably the superintendent's power would have it, but that's, I suggest, an issue for another day. I don't think it is wise because the four factors should be viewed collectively. in determining whether and to what extent someone should be sentenced to incarceration. It should not be, say, in the as we do in the restitution context, where we first determine a sentence and then look at restitution, where it's a two-step process, the first step dictating the extent of the second. Here, it should be, all factors should be weighed together in fashioning a sentence. And again, I believe that the trial judges who are on the ground and dealing with these issues every day are in the best position to deal with the weighing of those disparate factors. Unless the court has any other inquiry, I'm willing to rest on my brief.
All right, thank you.
Thank you very much.